Madam President, I thank you most sincerely for the opportunity to join this debate. Madam President, in my presentation, my intention is to firstly begin by addressing a pertinent concern raised by Senator Mark as it relates to the self-represented accused. I know it was also a concern echoed by Senator Vera, and similarly, I'm sure that there are many persons looking at this amendment, especially the layman, looking and hearing what was debated prior to my jumping into this debate, may have this sincere concern. And as a consequence of that, I will begin by looking at how this law and this amendment, how will it affect the self-represented accused. I would also, Madam President, make an attempt to look at the other safeguards that are presented and provided in other pieces of law that will continue to protect the rights of the accused persons, notwithstanding the amendments that we have brought to this Parliament today. Now, Madam President, this is a very serious matter, as I indicated. It is a serious concern. And I want, for the record, Madam President, for those like Senator Mark and the Honourable Senator Vieira, who are of the belief or who may be concerned that this in some way would adversely affect the self-represented accused, I want to reassure these senators together with the public and the citizens of Trinidad and Tobago that our self-represented accused in no way, Madam President, I respectfully submit, will be affected by said amendments. And I make this point relying on existing case law, Madam President, that speaks to the right and the responsibility of a magistrate to a self-represented accused. And that position, Madam President, I want to make it clear that notwithstanding this amendment that has come to the Parliament, that has hit the Parliament floor, this particular amendment is in no way going to disrupt settled case law, Madam President, as it relates to a self-represented person who appears before a magistrate and the responsibility in case law of that magistrate to that self-represented person. Now, Madam President, when I heard Senator Mark, immediately, of course, the lawyer in me was triggered. And I immediately started pulling some cases that I had the benefit of looking at when I was in practice as a defense counsel. And I think, also for the record, Madam President, why this issue of the self-accused person resonates with me is because of my previous incarnation. And the persons, Senator Mark spoke about us not understanding the man on the ground, but that is quite contrary from the truth. I certainly in a previous incarnation understood what, some legal ramifications, especially as a defense counsel, can bring to that man, and especially that man or woman who's unrepresented. So if I may respectfully assist my colleagues by taking us to the case, and this was one of the cases that I had relied upon. I remember in some submissions I had done on this very said point, was the case of Tomasevic and Travanglini. And this particular case, Madam President, is a 2007 case. It's a Victoria Supreme Court case, an Australian case. And this particular case, more or less, Madam President, it spoke to the responsibility that a magistrate has at all times, irrespective of what matter appears before that magistrate, the responsibility that that magistrate has to the self-represented accused. Now, in that particular judgment, Madam President, it was actually stated in the dicta by the learned Justice Bell of the Australian Supreme Court that as a part of their overriding obligation to ensure a fair trial, trial judges have a positive duty to give proper assistance to self-represented litigants, both in the criminal and the civil trials. Now, this case also further went on to say the same duty applies to masters, magistrates, commissions, and tribunals. So what we have is yes, the amendment that is presented before us has indeed removed the consent issue. But we have to remember this consent being removed from 64(2) does not in any way remove other existing settled case law that speaks to the responsibility and the duty of that judicial officer who is the magistrate, especially to that man on the ground or that regular Joe, as Senator Mark puts it, who appears before him for justice. Madam President, if I may also take this Honourable Senate to another case that I would have also had the benefit of reading and understanding when I practiced at the family court. Now, this particular case, Madam President, is the case of Johnson & Johnson. And for the record, it's 1997 FLC 92-764. Now, in this particular case, notwithstanding it's a family law case, Madam President, the court, and if I may read, the court considered a judge's duty to a litigant in person appearing in child proceedings, which resulted in a helpful, though not exhaustive, list of duties being enunciated. The court pronounced that a judicial officer is duty-bound, Madam President, to a self-represented accused. And how is he duty-bound, Madam President, to a self-represented accused? I would read from the dicta of that case. It says, to inform the litigant in person of the manner in which the trial is to proceed, the order of the calling of witnesses, and the right of which he or she has. Now, in that particular Johnson & Johnson case, Madam President, again, even though it's a family law case, remember the point is, it's a family law case that speaks to the responsibility of that judicial officer to a person who appears before him or her unrepresented. And these are just, it's not an exhaustive list, but these are some of the responsibilities coming out, Madam President, of the dicta of that case. To explain to the litigant in person any procedures relative to the litigation. To generally assist him or her in taking basic information from witnesses called, such as name, address, and occupation. C, if a change in the normal procedure is requested by the other parties, such as the calling of the witnesses out of turn, to explain to the unrepresented party the effect and perhaps the undesirability of the imposition of witnesses and his or her right to object to the court. This particular case, Madam President, went on in speaking to the responsibility of speaking to that point of the responsibility of that judicial officer to an unrepresented person, went on to say, if evidence is sought to be tendered, which is or may be inadmissible, to advise him, that is the unrepresented person, of his or her rights to object to inadmissible or material evidence. And the list goes on. And I'm sure my colleagues can make reference based on the citation that I would have presented of that list of the responsibilities of just this judicial officer to a self-represented person. Now, usually at this stage, I would throw Pekong at Senator Mark and tell him his whole argument, kilkite, based on, the Tomasevic and the Johnson & Johnson case. But I would refrain from doing that because I do understand this concern that the regular person listening to this particular amendment would have as it relates to, I'm an unrepresented man, I'm waiting for a legal aid appointment, I'm appearing in this matter, and now my right to consent has been taken from me. I am saying that, notwithstanding the amendment that has been brought in this case, there are other settled law, especially as we turn to the case law, that speaks to the responsibility, Madam President, of that judicial officer, of that magistrate, to this self-represented person. So, even though consent is taken away from the accused in this instance to agree whether he wants these matters to be tried jointly or severally, even though that has been withdrawn, we have to remember, I respectfully submit again, that this does not take away from the duty and the responsibility in settled law of that judicial officer, especially to those, Madam President, persons who are unrepresented. So I do hope that to some extent, this submission, as it relates to the self-represented person, Madam President, may assist, my colleagues in being able to, see what it is exactly that this government, what exactly the Attorney General has brought here today, and of course, at the end, give us the support that we require. Now, another point, Madam President, but I will now turn to the Honourable Senator Vieira. And Senator Vieira, Madam President, referred to the consent provision in the present 642 as a safeguard. And the Senator, in his, very well, and I could sense the emotion of the Senator and his serious concern that by removing this particular consent, what it does is that it removes a safeguard mechanism for the accused persons, right? Madam President, at this stage, what I want to look at is in answering to the Honourable Senator's concern, and I'm sure the Attorney General will address the issues that I don't, but in answering to some of those concerns relative to safeguard, Madam President, I would turn to, Madam President, a practical application of this particular amendment once it hits the ground of the court. Now, Madam President, and within that practical example, Madam President, what we will be able to see, what I'm hoping to be able to achieve, is to show my learned colleagues of this Senate that practically, even though consent has been removed, there are still going to be other safeguard mechanisms that will protect at all times the right of the accused person. Now, Madam President, because again, I have walked the floor of the criminal courts, I understand what would happen practically when this when this law, if this law is approved, if this law is assented to, right? What we would have, Madam President, is a case where a magistrate now, the judicial officer now decides, based on the matter that appears before him or her, at the magistrate court, there's a disclosure of what we call a summary of evidence. And the magistrate now would have an opportunity to review this summary of evidence. And the summary of evidence, more or less, provides a prima facie case of what the accused persons are there to answer to. Based on the summary of evidence, Madam President, the magistrate, in their experience, and for the record, not in an effort to simply push matters along or to reduce the backlog of cases that appears before us, the magistrate, in their discretion, of course, in operating in the magistrate mind, the issue of fair trial and all of that, looking at the summary of evidence, will then decide whether or not they would make the decision whether or not this matter should be heard jointly or severally. Now, Madam President, if a decision at that point in the magistrate court in particular, if a decision is taken by the magistrate that we are going to join this matter, at that stage in a practical proceeding and setting, counsel for the accused can then raise an objection and ask that they submit submissions to the magistrate that may possibly assist the magistrate in coming to another decision. So the magistrate's right at this stage, Madam President, is not unfettered. So in a practical sense, even though, yes, we are saying it is now to the discretion or at the discretion of the magistrate, who can then decide, based on the summary of evidence that appears before him and her, or her, whether this matter ought to be heard jointly or separately, at that stage, we still have a safeguard built in the practice of criminal law at the summary courts, whereby counsel can say, no, well, not Madam President, Your Worship, at this stage, we are not in agreement of the decision made, and may you, and ask for the opportunity, Madam President, to provide other learning and assistance to the court that may be able to assist the court in changing its mind. Now, the question comes into being, what if even after making submissions, the court is not minded to make a decision in the favor of the accused, which is hearing the matters jointly separately, as opposed to jointly? I know Senator Vieira, and very much like myself, he is concerned about the spate of judicial review we may have and the amount of judicial review that may come into existence by making the magistrate now responsible for making said decision. So yes, like the Senator, I'm concerned about judicial review. However, that does not take away from the fact that judicially reviewing the decision of the magistrate is yet another safeguard that is provided in the law to that accused person who, after the magistrate has made a decision and is not happy with that decision and wishes to contest that decision, we have that opportunity by virtue of judicial review that he can make. Now, judicial review applications, I can tell you that especially in my practice, I know sometimes, especially for clients who are impecunious, it's a relatively expensive process. What another option that is available, if at that stage you decide not to judicially review the application, then you can afford to let the matter run its course. And once a decision is made in the matter, Madam President, and that decision, let's say, again, is against, it's not in favor, and we have the accused person now convicted. Another safeguard is built into the law, and that is through appealing said decision. So what you have is that, so I'm just practically explaining for the benefit of the listening public, and hopefully in some small way to benefit my colleagues opposite, to understand that even though consent has been removed, there are other aspects of the law that would provide this protection. So I would have dealt with the protection that is provided in case law to the unrepresented person, Madam President, as found in and the cases that would have alluded to the responsibility that that judicial officer now has to discharge to this person. And now what I'm focusing on is the other safeguards. Other safeguards from a practical sense where you can have an oral application being made in the court. Two, where we could look at, yes, you can judicially review the decision, because that would be a tribunal and a tribunal decision that you can challenge. Three, if that does not, if you choose not to follow that option, there's also the appeal process. And, and of course, well, Section 128, one of the Summary Courts Act, would speak to the right of the appeal. When we look at the Judicial Review Act, we could look at Section 5 of the Judicial Review Act, Madam President, which speaks to this. On the point of judicial review, Madam President, there's also a very interesting case, a good read, especially for my colleagues who are lawyers, Regina versus the Hereford's Magistrate Court. It's an ex parte rulings. It's also a case that speaks to that safeguard that is provided by virtue of judicial but this is a judicial review case in particular, but it speaks nonetheless to the safeguard that it presents and provides that accused person with. Now, so, Madam President, in a nutshell, because of course, to get into the law in all of these areas, time simply will not permit. But in a nutshell, Madam President, what I've attempted to respectfully place on the record and submit for the, for the consideration of my honourable colleagues on the other side, is that notwithstanding consent being removed, again, we have the duty and responsibility in settled case law of the magistrate, the judicial officer, Madam President, to that unrepresented person, and then two other areas of settled law that provide safeguards to an accused person who may not be in agreement with the decision taken by a magistrate to join the matters. Now, Madam President, that being said, I would now jump. Madam President, can you tell me how much time is full time? How much more minutes I have?
Yes, if you take your full time, you will finish at 10 minutes past 4.
Okay, thank you, Madam President. So what I will now do, Madam President, having tried my very best to answer to those legal concerns, I would now get into the crux of my presentation. Now, in this, the Attorney General did an excellent job, as always, in the piloting of the bill by going through the length and breadth of the and focusing a lot on the policy, Madam President, behind the creation of this piece of legislation. Now, Madam President, to avoid tedious repetition, I would start with a case. And this is a very old case, Madam President, just for persons who are trying to understand or catch what's happening here today. I would start with the case of St. Johnson versus Washington. It's a 1955 case, but that case simply speaks to what occurred when the old law was in existence. And in this particular case, Madam President, what it stated is that once the record reflected that the magistrate did not, because there's written law, in 1955 there was the ordinance. Once the record is reflected that the magistrate did not inform the accused of his or her right to consent, And on the record, you saw that there was no consent at all. From that point onwards, what happened is that the accused person can then challenge the entire proceedings, deeming that the proceedings ought to have been invalidated by the failure of that consent. And that is pretty much where the whole interpretation of this particular ordinance, which eventually became statute, a law, an act, it began. And St. John's versus Washington spoke about the effect. And of course, there's a numerous case law from 1955 onwards. But this was kind of like a landmark case back then that would have spoken to that an entire proceeding can be invalidated as a consequence, Madam President, Mr. Vice President, of that particular provision. Now, from a practical sense, Madam President, so since then to now, we have had the accused persons, of course, exercising their right to consent, to not to consent or to consent, whether they want these matters to be heard jointly or severally. Now, the question is, and as a defense counsel, I'm sure the Honourable Senator Heater would be familiar with this as well. One of the major reasons why you would find that an accused person would have relied heavily on the statute speaking to consent is because of that whole cutthroat fear, the fear of the other accused person running a cutthroat defense. And it was very convenient that the law in its current incarnation simply required you to say yea or nay. And no reason was necessary, because certainly you are not, as defense counsel or accused person, is not going to say to the court, I am exercising I am not consenting, and I'm consenting because I'm fearful of a cutthroat defense that may be run by the other accused, because in the first place, you're removing yourself completely from the equation of that offense. So it was actually the section 64(2) was actually is a very convenient, because it is placed in such a way that you are not required to give an explanation, Mr. Vice President, as to what is your reason for wanting this matter to be joined or not joined. Now, sometimes the accused person, Mr. Vice President, would have exercised this particular right because of fear of personal delay of their matter. So, for example, if there's this matter where there are several persons charged, and you foresee counsel may advise the accused person that, hey, listen, in the other matters that appear on this complaint, there are several legal issues for the other accused persons that would arise. And it may be prudent for you to treat with your matter separately, because your matter is a simple matter that could be treated with and doesn't require much legal submissions and a further derailing of your matter. So for that reason as well, for their own personal reasons of not wanting to delay their matter, that is another reason why, Mr. Vice President, you may have had the accused relying upon this particular provision. Now, the Attorney General, so this is what would have been the practice. And then the Attorney General would have taken us to the decision that came in 2017. And that, of course, is the Fazal Dindial case. And in this Fazal Dindial case, of course, again, not to avoid tedious repetition, what we have here was where a different bar was set relative to the judicial officer choosing and what should operate, Mr. Vice President, in the judicial officer's mind when determining whether this matter should be heard jointly or severally, right? Mr. Vice President, what I want to deal with, though, is so we moved from 1955, and then I took you to the case of Johnson. Then we looked at why the accused would have relied upon this, and now the Attorney General, of course, would have gone into detail with the Fazal case, which I'm not going to go through. What we are looking at, so after 2017, I now want to look at what we have before us, which is this amendment. And this amendment, yes, as correctly stated by all members opposite and all those who have jumped into this debate thus far, it removes the consent element. My contribution from this point now is the question I want to ask and answer is: does a magistrate have the ability and based on the duty that is now being placed and the responsibility based on this amendment that is now being placed on the magistrate based on the amendment? can a magistrate and does a magistrate in law have the ability to make that decision? And my answer to that question, of course, is yes. Because to suggest otherwise simply is to suggest that...
Senator, you have 5 more minutes.
Thank you, Mr. Vice President, is to suggest that within our magistracy, we do not have persons who are competent enough to look at summary of evidence and based on their experience and knowledge and understanding of the law can make a decision as to whether or not these matters are to be heard jointly or severally. And I want to place on the record, and I'm sure as the Attorney General would have done, and I'm sure other persons who are in support of this bill would do, that the magistrate certainly is best positioned, being the first, being in a position to review the summary of evidence, is best positioned to be able to make that determination. And why so? Because I previously have spoken to what is the reason most of the times for the accused in preferring the consent position. Now, Mr. Vice President, so to answer the question, a magistrate can exercise his discretion to determine whether matters should be heard jointly or separately, and I said yes. To answer this, Mr. Vice President, several provisions, and if I turn to the law, several provisions under the Summary Courts Act and the Criminal Procedure Rules 2006 allows magistrates to exercise his discretion in the interest of justice and, more important, in keeping with the overriding objective of actively dealing with cases and justly dealing with cases. So yes, placing this responsibility squarely on the shoulders of a magistrate, my answer is yes, they're quite capable. One, their years of experience. Two, because at the end of the day, they sit on the bench. Further to that, the Summary Courts Act, and that's a very simple contribution there. But even if we turn to the law and we turn to the Summary Courts Act, we see that inherent in the law is their ability to be able to make this decision. So that is relative to whether a magistrate can do this. Now, finally, as I come to a close in my presentation, Mr. Vice President, because of course time would not permit me, like the Attorney General, I want to just briefly look at, and for the benefit of those opposite, understand, please, respectfully, that the amendment that we have brought today is good law. It is accepted law. It's a law that is brought to this Parliament after considerable consultation, and the Attorney General, the learned Attorney General would have gone through the list of stakeholders and their comments in this. From a practical point of view, why do I support this law from a practical point of view? It saves time on matters, on money. It saves time, Mr. Vice President, on matters. It assists in backlog reduction of matters. We look at it providing litigants with a fair trial. Of course, further to that, it saves the court financial resources. The Attorney General would have looked at the case of Clayton and Chief Constable of Norfolk. This particular amendment is I support it because it's also in alignment with that case and other cases. This particular amendment, Mr. Vice President, is also aligned with the Criminal Procedure Act, Chapter 1202. What we are doing is simply adopting a similar position that already exists in the High Court. Why do I support this amendment, Mr. Vice President? If we turn to regional comparators, for example, Section 95, Mr. Vice President, of the Magistrates Act, Chapter 116A of Barbados, speaks to this similar provision. Another international comparator, regional comparator, the AG would have looked at Guyana. He would have looked at the United Kingdom. So the international comparators is yet another reasons why I support it. And finally, we must take into consideration the interoperability of law. The criminal practice rules has hit the grounds of the court. We know what is the overriding objective of the criminal practice rules. And what this amendment will do is breathe more life and new life into the criminal practice rules, which no doubt will have the benefit of reducing backlog that faces our criminal justice system, more so the summary courts. So with these few words, Mr. Vice President, I thank you for the opportunity to make a small contribution to this debate.